May it please the Court, in this matter I appear on behalf of AP Wireless UK Ltd with my learned friend Mr Clark, King's Counsel. On Tower UK Ltd, the respondents to the appeal appear through Mr Lees, King's Counsel, with Miss Briggs of Counsel. My Lords, before I begin my submissions proper, there is a procedural issue which I have to raise in relation to my supplemental skeleton argument. The Court will be aware that an error occurred in relation to the submission of that, or an application for permission to rely on that. We were under the impression that the Court was going to decide that yesterday, but we don't know whether the Court has in fact decided it.
I have looked at this. I've skimmed your skeleton argument. I can see the point of it possibly in relation to the respondent's latest points. Why on earth are you entitled to put in anything in relation to the other points?
Well, my Lord, if the Court thinks that I've gone further than is necessary in relation to that, the Court can either ignore those points now or simply allow me to make those points orally. But the reason for responding to those points was to correct matters which were being asserted which weren't right. But obviously I can do that orally if the Court requires me to. I mean,
I have to say, on the one hand, I think, why on earth should you have permission to put in this document? On the other hand, I can't particularly see why it prejudices the respondents. I mean, Mr Lees, are you really maintaining an objection?
My Lord, the only issue is this. We agreed a timetable which allows an hour and 45 minutes for my learned friend's reply, which we consider to be relatively generous. And the reason for that was expressly so that he could address the points that we'd raised in our skeleton argument. Having agreed that, I appreciate this is my learned friend's fault personally, but having agreed that, it was only after that agreement we then are told there's a 16-page skeleton argument which purports to address the same points. So, in a sense, from my perspective, it sort of has to be either or to maintain fairness. If the document's in, I'm not sure my learned friend needs quite such a long and generous reply. If he's got the time to deal with it orally, I struggle to see why it should give him.
So just let me know what your agreed timetable is.
My understanding is my learned friend's got today. I then have tomorrow. We've got half a day on the third day, for which I'm allowed 45 minutes at the beginning. My learned friend has an hour and 45 minutes in reply at the moment. That's the agreed timetable. That allows my learned friend, I think I'm right in saying, an hour and a quarter longer. We took the view that that was appropriate in circumstances where he wished to respond to those points, which was one of the reasons given. Our objection to the document is, as your lordship says, firstly, it doesn't just confine itself to that, but secondly, it also is quite a lengthy document dealing with those points, which then, it seems to us, would be slightly unfair for him to get both a longer reply, such a long reply, and the document in. But we're in the Court's hands, of course.
Yes, I mean, looking at it the other way, at least you have notice of what they might want to say.
Well, I take that. I mean, these have all been argued below as well, so it's fair to say we had a pretty good sense of what they were going to be saying anyway.
Yes.
So my issue is simply that I'm very much willing to be in the Court's hands in terms of how we deal with it, but just in trying to maintain a balance. My own friend will say, well, he agreed the longer reply thinking it had gone in, because, of course, he was working on the assumption that his solicitors had applied to file it, but we didn't know that when we agreed the timetable.
Just going off at a tangent for a moment, I'm not quite sure why it's a 2.5-day case. Why can't you, between you, confine your submissions to 2 days?
Well, I suspect we can, and it may be my learned friend taking a much shorter reply would assist with that, and of course we'd have to shave some time off ourselves as well. Of course, my learned friend will have to respond to you on that as well, but we're certainly willing to do it within 2 days and think that is possible. But one has to bear in mind that if that document goes in, that's a bit one of the main reasons my learned friend had such a generous reply.
Mr Watkins.
Well, my Lord, in relation to the 2 days or 2.5 days point, I think my learned friend and I agreed 2.5 days on the basis that, although some of the Court will have some familiarity with the code, it's quite a detailed set of provisions, and I will have to take the Court through them in some detail so that the Court understands all the intricacies of how they work and where the issues therefore emerge. So that's really where the time is in relation to that. In relation, my learned friend is quite correct that when we agreed the timetable, I thought the skeleton was in. So that's a fault which is on my side of the divide. I accept that. My intention was to assist the Court and my learned friend by telegraphing my points before they arose, so the Court would know them when they prepared for the case. But if that hasn't been of assistance, I apologise to the Court. But the reply effectively will deal with whatever I haven't dealt with, which my learned friend hasn't. I need to after my learned friend sat down.
I think we'll let you keep your supplemental skeleton in, and I'm not going now to restrict the timetable, but at the same time, if between you can bring the case to a close by tomorrow night, then so much the better.
Well, my lord, we'll see how we get on. If I can finish within a day, I certainly will, and it may very well be that I can.
Yeah. Okay.
I'm grateful, my lord. On that basis, can I just map out the way in which I intend to, the Court's permission, intend to produce my submissions? Firstly, I'm going to introduce the issue and outline the parties' positions as I understand them. Then I'm going to take the Court very briefly through the instruments which are involved. I hardly need to touch those, but I need to identify where they are, and then through the code. I then wish to take the Court through GenComp, which the Court will be aware is the central decision. I'll then address my Lord, Mr Justice Fancourt's reasoning below, why our position is the correct one, and also attempt to address On Tower's arguments in relation to, in support of my Lord's original decision. And I will then address the Court on Tower's 3 alternative sets of reasoning. So that, with your Lordship's permission, that's the way I'll proceed. By way of introduction, then, the Court will be aware from pre-reading that we are dealing with 2 mobile phone mast sites, rural mast sites, one in Fields Farm in Sandbach, one Blackwell Grange Golf Club. There were originally 3 before the Court below. One of those fell away as a result of different preliminary issues decided by my Lord Mr Justice Edwin Johnson. I mention that only because we've made reference to that judgment, which also deals with one of the issues which is in this appeal. The agreements were originally made between landowners and with mobile network operators, that is, people who actually transmit to their customers. And they were contractual licenses. APW and On Tower were not the parties to them. With your permission, I'm going to refer to the parties as APW and On Tower, given there have been several appeals. APW acquired a freehold of Sandbach site and an intermediate lease of the Blackwell Grange site. On Tower, which was previously called Archiva Services Limited, is at the end of a long chain of assignments from the original contracting mobile network operator. The issue which arises in this appeal is whether, in respect of those contractual license agreements, On Tower is a, quote, party to the agreement, unquote, within the meaning of paragraph 33 within part 5 of the Electronic Communications Code. It arose on one of a number of preliminary issue hearings before Judge Jackson, and Judge Jackson and then my Lord Mr Justice Fancourt both held, for differing reasons, that On Tower was. My Lord held that the issues were finally balanced and gave permission to appeal. APW says that those decisions, for both those sets of reasons, were wrong. On Tower is not yet a party to the agreement, although it can make itself one. Strictly, of course, only the original parties to the agreement are parties to the agreement in the conventional sense. Paragraph 10 deems other people, paragraph 10 of the Code deems other people to be parties to the agreement in particular circumstances. The GenComp decision, strictly Vodafone against Pottingshed, as it was then called, decided that paragraph 10 was not comprehensive in relation to those people who should be considered parties to the agreement, who weren't the original contracting parties, and that Parliament intended the regime of the Code to work in such a way that the persons currently entitled to the benefit and burden of the agreements as operator, and the person currently entitled to the benefit and burden of the agreements as site provider, that's a quotation, as parties to the agreement can exercise the rights under Part 5. A party is thus standing in the shoes, a party thus standing in the shoes of the original contracting party is to be treated as a party to the agreement. In GenComp, the Court was considering a lease and considering the issue from the question of whether the site provider, which is how the people on that side of the equation are conventionally referred to in the Code and generally, are to be considered, whether the site provider in that case, being intermediate lessee, was a party to the agreement. But we say that the logic should be applied consistently, so that, for your lordships, a party to the agreement means the person currently with the burden and benefit of the agreement. Fundamentally, we say there's no need to stretch the concept of a party to the agreement, the contractual concept, any further than that. And that it's not appropriate to accord privileges more than the generic ones to someone who has not accepted the burdens of the agreement. For example, to modify those burdens. The burdens, of course, do not pass law on a contractual assignment of the benefit of the agreement, but one can still bind oneself as the recipient of the benefit of the contract to the other party to perform the burdens of that contract. And we say that is enough to bring yourself within what the code means by party to the agreement. My Lord, Mr Justice Fancourt held, we say correctly, that On Tower hasn't made itself subject to the burdens of the agreement, or at least hadn't established that it had. So it not being subject to the burdens, it's not standing in the shoes of the original licensee, and it's not to be treated as a party. On Tower's case below was that it was sufficient that it had only the benefit of the contract for it to be treated as a party to the agreement within the meaning of the code. Alternatively, it submitted that it was subject and is subject to all the burdens by virtue of the operation of paragraph 12 of the code, which we'll come to look at, which it says imprints, is the word it uses, imprints the burdens, all the burdens on all the benefits. Then thirdly, it said it was subject to all the benefits by virtue of what was left of either the conditional benefit and burden principle or the pure benefit and burden principle originally identified and then cut down in Tito and Waddell and Ronan and Stevens. Forgive me, subject to the burdens, I misspoke. It is subject to all of the burdens by virtue of the principle of benefit and burden just identified. Because all the burdens, it said, were inextricably linked to all of the benefits. Judge Jackson rejected On Tower's case that the burdens passed wholesale by virtue of the principle of mutual benefit and burden. My Lord, Mr Justice Fancourt concluded that that was clearly right, in his words, and it's not pressed here. The issue which is raised now, as I'll come to shortly, is slightly different in relation to those principles. Judge Jackson decided that it must follow from the fact that an operator is exercising code rights that it's a party to the agreement. As my Lord, Mr Justice Fancourt noted at paragraphs 56 and 58 to 58 of his judgment, which is in the core bundle at page 97, I won't ask you to turn that up now, he identified that that's a non sequitur, because rights can be enjoyed by people who are not parties to the agreement, but they can be enjoyed, for example, by sharers, and it doesn't follow that an operator who is exercising a right is a party to the agreement. That is not On Tower's case now, and it doesn't push that either. The third part of the decision was that that is Judge Jackson, concluded that if he was wrong about that, nevertheless he accepted On Tower's argument about the imprinting of terms under paragraph 12. He gave no reasons for that, and my Lord Mr Justice Fancourt rejected that argument. Given where we are, I don't propose to take you any further in relation to Judge Jackson's reasoning in relation to that, unless the court wishes me to do so. It has in a sense been superseded by the way in which On Tower now puts its case and the way in which the appeal went. Mr Justice Fancourt rejected each of On Tower's arguments as they were presented on the appeal. So he said it wasn't sufficient, that On Tower merely has the benefits of the agreement, and he concluded that the mere assignee, a bare assignee of the rights under the contract, would not be a party to the agreement. He also rejected the benefit and burden arguments again, and he also rejected the paragraph 12 arguments. He held, however, that the assignee of the benefit of an agreement, who was not subject to its burdens, would still be treated as a party to the agreement if it had, quote, assumed primary responsibility for performing the obligations of the licence agreement. And it would do so, for example, by covenanting with its predecessor assignor to comply with the obligations of the agreement. And that was true even if that covenant to its predecessor entitled, if I can use that term slightly incorrectly, even if that covenant was only by way of indemnity, and even if, as here, the covenants are only expressed to endure for the term of the original agreement, whereas now, of course, the agreements are continuing by statutory effect. He explicitly held that it doesn't matter that APW has no recourse against On Tower for any breach or non-compliance with the agreement at all, even through the chain of indemnities. APW says that's wrong, and consistently with GenCom, as I've already said, On Tower must have the benefits and be subject to the burdens, otherwise it's not standing in the shoes. We say that my Lord Mr Justice Fancourt's solution has no significant advantages over On Tower's bare assignment is enough argument, which my Lord rightly rejected. The policy of the Code cannot have been to make the status of party to the agreement so as to govern whether or not my client needs to deal with that party, dependent on something which is entirely irrelevant to the relationship between those parties, i.e. the existence or otherwise of a limited covenant of indemnity entirely on the other side of the fence. The responsibility to the site provider of the person exercising code rights cannot sensibly be immaterial, a word I use for reasons which will become apparent later in my submissions, to their status as a party to the agreement, particularly given the provisions of the code which address breach of obligations under the agreement. On Tower's position on this appeal is still that benefit is enough. It's still that it has all of the burdens because of paragraph 12. It now runs a new case. It's a variation on the application of the benefits and burdens principles, which is that it's sufficient that On Tower is subject to those burdens which are inextricably linked to the benefits which it enjoys. It therefore says, by definition, those burdens will have passed, so that any assignee of a licence will be subject to sufficient burdens to be a party to the agreement, even though it's not subject to the bulk of the obligations. So effectively, it is saying that those burdens which have to pass are enough. So benefits and those burdens which have to pass are the way in which it puts its case. Before moving to the agreements themselves and the terms of the code, I just want to deal with some of the what I might call alarmism on the part of On Tower as an operator in relation to the effect of the submissions which are being made to this court. You will have seen at paragraph 3 of their skeleton argument, which for your notes is in the core bundle at page 56. On Tower begins its response to this appeal by saying that thousands of operators will be effectively barred from renewal of their agreements under paragraph 5, if we are right. And at paragraph 52, it uses the language of being locked out of paragraph 5. With respect, that is just wrong. And it's not a sustainable position on the basis of what's been put before the courts and what the court has previously accepted. And indeed, the basis of the way in which the appeal is resisted. All that has to happen if On Tower wishes to make itself a party to the agreement is to give a deed, unilateral deed, if necessary, to its site provider saying that it will perform the obligations of the agreement. If it does that, everybody becomes in effectively the position of the original parties to the agreement and therefore should be treated as parties to the agreement. Another point which On Tower has made is, paragraph 53 of that same skeleton argument, is that it's essential for investors in this industry that there should be certainty on the part of operators as to their rights to assign and to renew their agreements. Again, we say they can always assign and renew their agreements. They simply cannot have the privilege of those rights to assign and renew and the various sub-privileges which go along with the process of assignment and renewal if they haven't signed themselves up to the obligations of the agreement. And then the further point which is variously made is the threat to operators of the loss of sites. This may lead, in a way that Parliament did not intend, to the loss of a telecommunications site. Even if these agreements were to come to an end in relation to this, as I will show the court, firstly, nobody is saying, including On Tower, that they cannot apply under Part 4 for a new agreement. That's everybody's position. If you're shut out of Part 5, then you're not shut out of Part 4, is the purport of a decision of the Supreme Court, which I'll come to. But in any event, the way that the code works, as I will show the court, is that even operators who have no form of right to be on land have a form of security of tenure. They have a status of qualified irremovability, allowing them to be warned off, for there to have to be court proceedings to get them off, and for them to be able to defend those proceedings on the basis that they're applying for new rights. So there is no risk at all. I'll come back to that, but that's to set the scene of what's in dispute in relation to this and what the risks and benefits are. In relation to the agreements and assignments themselves, I'm not sure it's terribly useful for me to take you through these agreements. They're all of a very similar form. I'm sure the court has found them already, but they're in the supplemental bundle. The one relating to Sandbatch is in the supplemental bundle at page 236.
Meaning you suggest we get it out?
No, I'm suggesting that I'm just giving you the references in case that it's useful to have them here. The agreement at Sandbatch, but I will describe some characteristics of them if the court wishes to look at them as a result of that. I don't think it will. So the agreement at Sandbatch is at 236. That's an agreement which was made in 1997, therefore under the currency of the previous code. And it was made with a mobile phone network operator, as I've said, Orange Personal Communications. It has a list of rights, it has fees, it has a minimum term of 10 years, and it's made subject to its terms, which contain a whole raft of obligations. They include obligations on the part of the site provider to provide access to the site, for example, and it provides rights, such as the rights to add more antennae in certain circumstances, and obligations on the operator, obviously, to pay the licence fee, but also to do things like maintain a stock-proof fence. A whole raft of obligations. It's also expressed to be intended to bind successors in title. That was an aspect of the agreements which was prayed in aid in one of the other preliminary hearings, the one that went to my Lord Mr Justice Edwin Johnson, which he decided a raft of issues about whether or not these agreements, well, there were 14 of them, were leases or licenses. There's a degree of tactical, because under the old code, there could be different advantages depending on whether they were leases or licenses. They were tactically worded, so as you could argue both, one might have suspected. But in these cases, there's still an issue whether the lease or license has advantages to one or other side of the parties. And so there was a debate about that. And that went to my Lord Mr Justice Edwin Johnson. And it was pointed out that they were intended to bind successors in title, or at least this one was. In terms of the history of the sites, and this I would invite you to find, it's in the core bundle. This is recited by my Lord Mr Justice Fancourt at page 85 of the core bundle.
You mean in the decision?
In the decision, yes. Sorry, if the court has it out separately. It's paragraph 13 I'm aiming at.
Yes.
So 13, the, as it were, conveyancing history on the side of the, well, both parties, in fact, is recited, and 14 is the equivalent for Blackwell Grange. The first point to note in relation to Sandbach is the second bullet point. So the first bullet point recites the licence itself. The second bullet point is the first assignment. So Orange assigned to Everything Everywhere Limited, now EE Limited, and Hutchison 3G UK Limited together. What was then described as a lease, subject to the paying and performance of the rents and obligations of the lease and obligations. There was no, in that situation, indemnity covenant. Doesn't appear to have been an indemnity covenant in relation to that assignment. At least one has never been produced, although I don't think we have a full copy of that agreement. So, although there are indemnity covenants further on in the chain in relation to that one, that's simply to illustrate the fact, although it's obviously a point of principle, that the facts that the judge was considering below were that there has been a break in the chain of the assignments.
Can I ask what subject to performance of the lease obligations mean?
I'm not. It was assigned subject to performance, but I'm not sure that that was in a covenant to perform.
Okay.
But Lord, I can take you to it and show you if that helps. But it's not. I think everyone has accepted that there isn't, or at least hasn't been demonstrated to be an indemnity covenant in relation to that.
But you could have either an indemnity or you could have a...
You could have positive covenant to perform it, yes.
Then you had neither, and that's the gap in the chain.
That's the gap in the chain in that situation. And there are, in fact, there were 3 of these, and there have been lots of others, 14 originally. One could, if one wanted to, find a fact pattern for all sorts of breaks all over the place. I'm not praying particularly for this case that, simply the way in which it was decided, as we'll see later on, the court was indifferent to the fact that there was or might be a break in the chain of covenants in relation to this, these assignments.
Can I just ask, if there is a break in the chain of express covenants,
Yes.
Does the principle in Moore and Garrett apply?
My lord will have to remind me of the principle in Moore and Garrett.
It's dealt with in a court. I can't remember. It's a Court of Appeal decision called Selous in the 1980s, and it's based on the principle of law restitution, that there is an implied sequence of indemnities.
Subrogations, my lord, as it were, through the chain of
I don't remember
assignments.
it being described like that, but I wondered whether Moore and Garrett, which I think was decided in about 1877, might have some bearing on this.
Well, my lord, I don't think... Let me put it this way. My lord may be right, and I can check overnight. I'm sure my lord is right, of course.
Well, I wouldn't assume.
But my lord, let us assume that my lord is right, that there is a chain of effective assignments. The point that I'm making is not that there is or isn't an effective chain of assignments in this case. The point that I'm trying to illustrate is that the basis upon which it was decided below was that it didn't matter whether there was a break in the chain of assignments in this case. So how the principle would operate
may depend upon whether or not there is no break because of an implied indemnity.
My lord, yes, except that what I'm really directing myself towards the reasoning of the court below. This court below certainly didn't proceed on the basis that there indeed had to be a chain of assignments. There is a point in the supplementary judgment where my lord, Mr Justice Fancourt, says in terms, I do not make this decision on the basis that there has to be a chain of assignments, indemnities. So, my lord, that is all I need to show you in relation to the Sandbach agreement.
The only other question on this is, do we need to know what you say are the burdens, the relevant burdens, for the purposes of looking at the question of principle?
Well, my lord, not for the purposes of looking at principle, I would say. If you wish me to take you through the agreements to show you the burdens of the agreements, they vary across the agreements, but the agreements include things like burdens in the future to restore properties are regularly occurring. I'm not reminding myself of these ones particularly, but ones which are common in these agreements. Burdens to fence, burdens to keep things in repair, either the equipment or the site. You see variations in relation to those situations.
I was just looking quickly. There's one to insure, I think.
My lord, it's often an obligation to insure. Sometimes in more modern agreements you get obligations to indemnify. There can be a very wide range of obligations in relation to the way the future of the site operates. But it's certainly right that some of them, in some circumstances, arise at the end, at the conclusion of the agreement, when the person walks away. So the obligation to restore the site, for example.
Thank you.
The only other observation, my lord, to make in relation to the Blackwell Grange agreement itself, first of all, which is at 269 of the supplementary bundle. Firstly, it was for a fixed term, whereas Sandbach was until determined by notice. Blackwell Grange was for a fixed term. It was in 2007, so still made when the old code was present. And it expired therefore in 2022. And it does include a covenant, perhaps we should just look at this, a requirement for an assignee to provide a covenant. So, my lord, it's behind tab 27, if you're all on paper, I think, my lord, are.
Sorry, tab.
27.
Thank you.
And it's paragraph 9, 4, on page 277. Every assignee shall covenant directly with the owner to observe the terms of this agreement. Now, you would have seen in the earlier paragraphs 9.1 to 9.3, there are consent requirements or not, depending on the status of the company that you're assigning to. So 9.1, you can assign freely to group companies. 9.2, you require consent to non-group companies. But in all cases, there should have been a covenant. And there hasn't been from On Tower. There was one once in one of the assignments, or in fact it contained a license to assign, earlier in the chain. And again, that's referred to by my lord in his summary of the conveyancing history of Blackwell Grange, paragraph 14. It's the second bullet point, which contains forgive me, it's the third bullet point. Fourth bullet point, excuse me. Third bullet point on page 87. So, my lord, that's all you need to know, I think, about the agreements and the conveyancing history. Next, my lord, with your permission, I will introduce the court and take through the code and the bits of the code which I say are relevant. The Electronic Communications Code, that is Schedule 3A of the Communications Act 2003, replaced the Telecommunications Code, which was originally Schedule 2 of the Telecommunications Act 1984, with effect from the 28th of December 2017. It now regulates the relationships between telecoms operators, that's a term of art, and owners and occupiers of land. Operators have to be designated under the Act by Ofcom through a direction, and they provide one or other of two things. One is an electronic communications network. Those are the people who provide your mobile phone service to you. Or they provide an infrastructure system, as it's termed by the code, which is to be used by a mobile network operator. Those that provide infrastructure systems are referred to frequently as wholesale infrastructure providers, or WIPs. So you see MNO and WIP as the two forms of operator regularly. On Tower is a WIP. It provides tower sites. So it will have customers who are themselves operators, as it points out. some of the people it provides services to are operators, and who will be utilising the code rights which have been granted by keeping their aerials on the site. So conventionally, passive infrastructure like masts and boxes and things like that is owned by the WIP, but the actual box that transmits the signal is owned by the mobile phone infrastructure provider, mobile network operator, I should say. The code deals with what are called code rights. Operators clearly have to have, in order to put apparatus on land, they have to have a right to do so, and the code identifies a menu of those rights. So can I invite the courts to find the second bundle of authorities, tab 14, which is where the new code is to be found, and find paragraph 3, which is on 377. I must apologise that the way in which this has been reproduced, it's not always easy to see which part you're in, because their part headings don't appear themselves, but they do appear in the footnotes. So you can always see in the footnotes. So we're currently in part 1, which is called Key Concepts. And you see on page 377 the code rights. And what you have there is, in subparagraphs 1a to 1i, a closed list of code rights. They have been amended, in fact, and added to. And that was partially to make clear the extent of the degree to which sharing was permitted under the code. So one sees at subparagraph 1 sub CA and EA, those are provisions which make reference to, explicit reference to the sharing with another operator of the use of electronic communications equipment, which was always intended. But it was, as it were, it was elevated from being something which might be a term of the agreement into something which was a code right. But otherwise, the rights can be very general. So, for example, A is the right to install electronic communications on, under, or over land. And I will come back later to why the generality of the way in which the code rights are expressed becomes important. Code rights are conferred ideally by agreement. And part 2 of the code deals is headed conferral of code rights and their exercise. And if we turn to paragraph 9, which is on page 384, and headed who may confer code rights, sub 1, a code right in respect of any land may only be conferred by, on an operator by an agreement between the occupier of the land and the operator. Come on to what the occupier of the land is, but, well, I'll deal with it now, in fact. So, as you can see, obviously, it may be that the occupier of land has a lower level of rights than you might require, and we'll come on to deal with that later. The occupier of land means what it says. There's a hierarchy of occupation, as it were. In this sense, if there is an occupier, it is the occupier. If the land is unoccupied, it is the person who is exercising management or control over the land. And if there isn't one of those, it's every person whose interest would be prejudicially affected by the code right. And you find that hierarchy in paragraph 105 of the code, which is on page 451. I don't think it's terribly important to look at that. It's quite a detailed provision, but just to understand that effectively you end up going through people in active occupation, then controlling the land, and then ultimately to the landowner who can confer the rights. Now, if the land is unoccupied, you may get straight to the landowner as the person conferring the right, but not necessarily. Can I draw the court's attention to paragraph 9.2? I'll just read this. But in a case where an operator, the first operator, has the right to share the use of electronic communications apparatus with another operator, the second operator, under or by virtue of an agreement under this part, by subparagraph 1 does not prevent the agreement from providing for the first operator to permit the second operator to exercise, in connection with the sharing, a code right conferred on the first operator by agreement. Again, another clarificatory provision, as it were, amendment. And what this is saying is, just because code rights have to be conferred by the occupier of land on an operator, that does not mean that operator cannot license somebody further down to use the code rights themselves. seems to be what that is getting at. Paragraph 11 I'll come back to paragraph 10, but paragraph 11 is the requirements for an agreement. I simply need to, that's on 387, I simply need to point out to you that it requires signed writing to create a code agreement, and also to point out that it's a requirement that the code agreement must state the period of the agreement or how long it comes to be exercisable for. And of course, it would have been possible under the old code to create an agreement which lasted forever. But in fact, one would imagine that all agreements had some provision in it dealing with how long they lasted or whether they could be determined. Code agreements can still be, as they always could be, either a lease or a license. However, the ambiguity under the old code about the interaction between the code and the 1954 Landlord and Tenant Act, which protects leases of premises occupied for business purposes, has been hopefully removed by the new code and the amendments to the 1954 Act. So you're either within one or the other. A new lease, whose primary purpose is to grant code rights, is within the code. Old 54 Act leases remain 54 Act leases. They get renewed under the 54 Act, but the new agreement is also under the code. So we've dealt with who can confer a code right on an operator. If we turn back to page 385, and this is obviously one of the central provisions, so paragraph 10, this is headed who else is bound by code rights. Paragraphs 10, 1 and 2 make provisions for circumstances in which there's a dealing with the land, as it were. So the person who confers it is, in this paragraph, is described as O. If they're the occupier of land when the code right is conferred, if O had an interest in the land when the right was conferred, the right also binds successors in title to that interest, so 2A, and B, a person with an interest in the land that's created after the right and is derived from the right. So successors in title and those who have rights carved out of the interest of the original conferrer. And then also C, to see anybody else who's in occupation as a result of the largesse of those people. And then 3 says a successor in title, so that's only one of the categories, that's only the category in 2A, who is bound by a code right by virtue of subparagraph 2A, is to be treated as a party to the agreement by which the O conferred the right. So although all of those people are bound by the code right, and indeed a person with a limited interest carved out of it might be the landlord, as it was in GenComp, the provisions of the code themselves only specify that a party to the agreement is a successor in title. Paragraph 4 and the subsequent provisions deal with another situation, because of course the occupier may not be the only person who is likely to be affected by the right in the future, and the operator will wish to make sure that its rights are good against all the people who might have superior interests. Paragraph 4 provides that even if you weren't the conferring party, you can agree to be bound by the agreement which has been created by the conferring party. That's what sub 4 does. And as we'll see in the future, in the same way that you can apply for an agreement to be imposed on someone, always the occupier, you can equally apply to the court to bind somebody with a superior interest as well. And then subparagraph 5 and 6 deal with the same scenario, i.e. dealings with that person's interest, as did 2 and 3 in relation to the people actually granting the agreement. That is, it deals with successors, persons with derivative interests, occupiers, and again, it only deems the successor in title to be a party to the agreement. And it was that those provisions and the existence of this is only dealing in this provision with people on the site provider side. But these provisions are, on the face of it, a closed list of people who, other than the original party to the agreement on the site provider side, is a party to the agreement. And that's what created the problem in relation to GenComp. And of course, there's no reference here to operators being bound by anything in these provisions. The next provision, which is material, is on page 388, which is paragraph 12, which is headed the exercise of code rights. This is paragraph 12. What is the provision which my learned friend relies upon for his proposition that terms are imprinted on code rights? A code right is exercisable only in accordance with the terms subject to which it's conferred. And then 2 says anything done by an operator in exercise of a code right conferred under this in relation to any land use should be treated as done in the exercise of a statutory power. And then paragraph 3 deals with a number of situations where the statutory immunity created by 2 won't apply. I only mention paragraph 3 because you might notice, if more eagle-eyed members of the court might notice in 4 sub A, sub B, sub Roman numeral 2, a reference to a party to the agreement. Just to reassure you, that's the wrong agreement. That's the agreement, the land agreement, which is being referred to earlier in that provision. So that can be ignored. It's nothing to do with what we're dealing with here. And there are similar provisions to these in the old code, which are also made by my learned friend. And we say what's going on here is that one is effectively simply saying if you have a right to do something which is subject to some limitation, for example, temporal, or the requirement to give notice, you can exercise your code right, but you can only exercise it within the terms which it is created. And the second point is that even though the code rights themselves are expressed in general terms, so agreements confer code rights, a code right is defined as, for example, the right to install equipment. Despite the fact that you've been granted a right to install equipment, that does not mean you have a general right to install any equipment on land because you now have a code right. All you have is the code right defined by within the limits of what's created. And that fits together with 2, which is defining the extent of your statutory immunity. Your statutory immunity is for things arising from the exercise of code rights, which is the limited right to which you have just been granted. And that's what it's doing, we say. My learned friend says it's imprinting the terms, but we'll come to that. At this stage, I'm going to skip over part 3 of the code, if I may, and go straight to part 4 of the code, which begins on 401. So part 2 of the code dealt with effectively the creation of agreements voluntarily. Part 4 deals with the compulsory imposition. And it's headed, if you look in the footnote at the footer there, power of the court to impose agreement. 19 is the way the code writes at the beginning of each part. There's a section which simply tells you what's in the part. So actually the substantial provisions begin at 20. And effectively it's a compulsory process to impose an agreement on the occupier, still the occupier only, or to impose an agreement binding the agreement you've just created, making the agreement which you've just created binding on somebody else. And in very brief summary, the operator has to serve a notice. If there hasn't been an agreement within 28 days, they can make a court application, whereupon the court can impose an agreement. The test the court is imposing is in paragraph 21 in 404. And effectively, there is what's been referred to in paragraphs 2 and 3, 2 conditions which are together referred to as the public benefit test. So the first condition is that the prejudice caused by the imposition of this is capable of being adequately compensated in money. And the second is that the public benefit likely to result from the making of the order outweighs the prejudice caused to that person. So there's a prejudice test in relation to this, assuming that they can be compensated for that prejudice. And then 4 is important. 4 says when you're deciding whether where the balance lies, the court must have regard to the public interest and access to a choice of high quality electronic communication services. And the effect of that on the authorities which have considered paragraph 21, which aren't before you, is that there's a high hurdle. Public benefit is very easy to establish for operators. Effectively, it's assumed because they're putting something in to serve the public by providing a public benefit. So it would take unusual facts to be able to argue that there's no public benefit. It has been argued, it is being argued, but it's on very unusual facts. And then the authorities say that given the benefit to the public, there has to be a high degree of prejudice, as it were. It's a high hurdle to say that the balance doesn't favour granting those rights, given that the court has to have regard to the choice, and Parliament wants to roll out mobile phone communications. So it's not a great hurdle for the operators to have to overcome, and in practice the public benefit is usually established by simply saying we are an operator and we want this land to operate. The other thing to note is paragraph 21.5, and paragraph 21.5 is effectively a bar to the imposition of the agreement on the grounds that the relevant person, that's the person who's being subjected to the application, wishes to redevelop the land or neighbouring land, and couldn't reasonably do so if the mast is put on there. So like the 54 Act, in relation to the renewal of it, if the landlord wants to redevelop, that's an absolute bar to the grant of a new agreement. Paragraph 22 says that an agreement which is imposed takes effect as an agreement under Part 2, i.e. a consensual agreement. And then 23 to 25 deal with things like the court's power to fiddle with the terms which the operator wants, the consideration which is payable, and any compensation which is payable. At this point, before returning to the code, I'd like to make 2 digressions into other matters. The first one is to refer the court to the decision of the Supreme Court in Compton Beecham. I'm sure the court's already aware of this from the submissions, but it appears in the authorities bundle at tab 10. I'm not going to take you very much of it. It begins at 208 if people are working electronically. What Compton Beecham deals with is this problem. What happens if an operator is already on the land and wants a new agreement or a new right? The problem is created because paragraph 105, which I referred you to but didn't show you, makes it clear that the occupier is the occupier. If the land is occupied, that's the person who confers the agreement. And if you're the mobile phone company occupying the land, you can't confer the agreement on yourself. What the Supreme Court decided was where an operator uses paragraph 20, the Part 4 process, to get a new agreement on a right not yet conferred, its own occupation, the occupation of the person making the application, is disregarded. So you move down or up the hierarchy of occupations, depending on which one you're looking at down or up. And that, although you won't find that in the code, a paragraph of this decision, which is very regularly referred to from my Lady Rose's judgment, it's paragraph 106 on page 234. It is fair to say that this paragraph has had to be pralinated a very great deal in relation to the code, the drafting of which leaves something to be desired. And effectively, it is this, that the starting point here is not to try and define the word occupier and then allow that definition to mandate how the regime is established by the code. The correct approach is to work out how the regime is intended to work and then consider what meaning should be attributed to the word occupier so as best to achieve that goal. And that clause has had to be used a very great deal to manipulate the the provisions to make them work, away from what might be considered to be their literal meaning. So, Compton Beecham decides that an incumbent operator, for example, who has got no code agreement, which can occur, as I will explain later, can use Part 4, even though they're the occupier themselves. Equally, an incumbent operator who has got a code agreement but can't modify it, the usual reason for not being able to modify it is because the original contractual term is still running, can get a new code right by using Part 4 as well. What the Supreme Court also held was what operators could not do, and which they were attempting to do, was use Part 4 as a way of bypassing either a 1954 Act renewal, so where the original agreement was a tenancy subject to the 1954 Act, or to bypass the process under Part 5 in circumstances where they had access to Part 5, which they don't always do. So that's how I mention this now because this is how Part 4 operates. So this is part of the texture of Part 4, given the way it's been interpreted. The next point to refer to is, the second digression, is that obviously there were code agreements before there was the code, as it were. This code, the telecommunications code, preceded it. The old code was more limited and was different in many respects. The court will be pleased to hear, going to take you through those provisions. Code rights were still imposed by written agreements, which still had to be in writing, and they could still be a lease or a license. Otherwise, the normal law of contract and landlord and tenant applied in relation to them. The way the code effectively overlaid that was firstly that there was a compulsory acquisition process. So if you weren't being given one by the person you wanted from, you could go and get one. And secondly, unlike this code, and unlike the 54 Act, there was no statutory continuation process. They just expired. But instead is the wrong word. But what happened in that situation was that the operator had a qualified status of irremovability, if I can call it that. So the way that worked was the operator stayed on the land, and if the landowner wanted them off again, they had to give them a notice requiring them to leave. The operator then had to serve a counter notice saying, no, I'm going to apply for new rights. And then if they didn't agree on, it went back into the process of applying for a compulsory rights. And that would determine effectively the process of the right to continue to stay there. So agreements would just expire. If an old agreement had not expired by the 28th of December 2017, as was the case in both of these cases, transitional provisions then kick in, which is in Schedule 2 to the Digital Economy Act 2017. Another joy of the code is that the provisions are dotted all over the legislation. The Digital Economy Act was the one which amended the Communications Act by inserting the code into the Communications Act and deleted it from where it used to be, which is the Telecommunications Act. And Schedule 2, if I can take you to that, it's behind tab 15 of the Second Authorities Bundle. It begins at 453. And it adopts the term subsisting agreement. So paragraph 1, subparagraph 4, a subsisting agreement means an agreement for the purposes of paragraph 2 or 3 of the existing code. You don't need to worry about B. But effectively, that means if you had an agreement which would have qualified as an agreement under the old code, it will be called a subsisting agreement under the new code. And then paragraph 2, going over the page, a subsisting agreement has effect after the new code comes into force as an agreement under Part 2 of the new code between the same parties, subject to the modifications made by this schedule. And the key modification for our purposes is on page 457, paragraph 5, which has also been amended. One always thinks it's a bad sign when the transitional provisions start getting amended. But paragraph 5 used to say that part 3 of the code doesn't apply. It doesn't quite say that anymore, but it basically does. It leaves in place, or rather inserts, a very specific provision dealing with copper wire under land effectively. So there's a provision, if you look at 5A, what's inserted here is a provision which is new in both in the real code and in the transitional provisions. We don't need to worry about it, but it's dealing only with operators who keep stuff under land. And the intention of all of this was to make provision to allow, I won't bore you with how it works, but to allow the conversion of copper wire into fibre, effectively. So that was stuck into part 3 of the code, and it was also stuck into the transitional provision, so it would apply. But you can run on the basis that part 3 of the code, when it was enacted, didn't apply, and nothing has changed to make it apply in a relevant way. Part 3 simply doesn't apply for all the purposes that we're dealing with. And part 3, as we'll see, deals with various things, and as my Lord Fancourt observed at paragraph 21 of his judgment, this is giving effect to one of Parliament's decisions, or the government's decision on the advice of the Law Commission, which was then enacted through Parliament, about the non-retrospectivity of the code, generally speaking. It was leaving alone the arrangements which have been put in place.
It may not matter, but does the provision in paragraph 30 for the continuation of code rights apply to subsisting agreements?
Yes, it does, and we'll get to that, my Lord, it does.
Sorry.
Yes, or the effect of the things which are switched off are only material for this appeal because they fiddle with the terms and things. But yes, all subsisting agreements get the continuation provisions of the code. However, and this leads me to the next point, my Lord, which is that if an old agreement under the old code had expired before the new code came in, which is not uncommon, then there wouldn't be a subsisting agreement, nothing subsisted, and therefore you would have a situation where you had an operator on land with a mast, but no code agreement at that stage. That's a scenario in which the operator would be applying under Part 4 for a new agreement, for example. If we can now return to Part 4, which is behind tab 14, I just invite you to note paragraphs 26 and 27, which are on pages 412 and 415. They deal respectively with what's called interim code rights and temporary code rights. Temporary code rights are interim and interim code rights are temporary, so it's not a very useful way of distinguishing between the two. Effectively what this does is allows an operator to have rights for a short period for effectively one of two different scenarios. And the only difference between the provisions, really the material difference, is the test which is being applied in relation to them. Under the interim codes provisions, under 26, what you have to satisfy the tribunal of, or they still have a discretion, is that you've got a real prospect of getting a real agreement, although it's been interpreted in a much more broad way than that. Under 27 is attempting to deal with situations where someone is on land and they don't have a code right, but they need one temporarily while a new code agreement is created. And so there's a provision there which you can go effectively serve a notice and go straight to court to get any rights you need if you're stuck on land without rights. And that's one of the ways in which the code makes sure that there's no risk to operators. Nothing that we say makes any difference to that. So having dealt with Part 4 and having pointed out that Part 3 doesn't apply, we now have to look at Part 3, notwithstanding the fact that it doesn't apply. And if I can take you to page 392, here the introductory paragraph is quite useful in the sense that it tells you in a nutshell what Part 3 does. And indeed the heading, which is in the footer, tells you as well, assignment of code rights and upgrading and sharing of apparatus. And that's what Part 3 deals with. And these are the bits which are switched off for subsisting rights. And that's effectively because what's happening here is that for the future, for new code agreements, it's making it automatic that you have a right under particular circumstances and with certain limitations to assign, and an automatic minimum right to share the use of the equipment. But none of those two things applies to subsisting agreements. So the retrospectivity, non-retrospectivity respect is accorded by not imposing those freedoms in a contractual relationship which predated the code. Paragraph 16, which is the assignment provisions, is relevant even though it doesn't apply, and indeed because it doesn't apply. So paragraph 16.1 effectively prevents or turns off any non-assignment clauses in any agreement. So it's effectively a way of making sure that all agreements are assignable, subject to 2, which allows a requirement for a guarantor. And that's quite important here because it demonstrates that the court was keen, one of the ways in which the court was keen to make sure that the site provider wasn't prejudiced by the change in identity of the operator. In this case, because of the weakness, possible weakness of the operator's covenant. And then paragraph 4, subparagraph 4 is the key one here, which is from the time when the assignment of the agreement under Part 2 of this code takes effect, the assignee is bound by the terms of the agreement. So if you have obviously if the agreement is a lease, this provision is not doing anything because that would be the automatic effect of an assignment of the lease. The lessee would become bound by the terms of the agreement. What this is doing, and we'll see why it does this.
Well, it is doing something, isn't it? If you see subparagraph 4 as a quid pro quo for subparagraph 1. Because subparagraph 1 would apply to a lease, but this overrides any prohibition on assignment.
It does, my lord, but I see what you mean. But my lord, if it was a lease anyway, you could just override.
If it was a lease which you couldn't assign. Yes.
If you switch off the assignment in that situation without paragraph 4, the point that I was making, my lord, is that the assignee of the lease would still be bound by the covenants of the lease. What paragraph 4 is saying is if it's a contract, then the quid pro quo, as your lordship correctly says, for switching off the prohibitions on the assignment.
And in the lease situation, the extent to which an assignee is bound by the covenants is dealt with by the 1995 Act?
Yes, my lord.
So it wouldn't apply, for example, to a personal covenant in a lease?
Yes, my lord, that's true. It wouldn't apply to a personal covenant.
Mr Justice Fancourt, I think.
Yes, my lord, that's absolutely right.
So it's not as if all burdens necessarily pass to assignees?
Well, you mean without the assistance of paragraph 16.4, my lord? Yes, that's true. That's true. That's absolutely true. So, my lord, 16.4 is effectively, there has been GenComp deals with this in more detail, but we'll come to the reasoning for this in full details. But the origin of 16.4 is to make sure the purpose of it, although it is wider, as my lord points out. The purpose of it was specifically intended doing something that the Law Commission made it clear had to be done, which is if way-leave licence type agreements were to be assignable under the new code, you needed to make sure that the burdens of them passed. That was what it was directed at, although I accept my lord's point, which is that if the Covenants Act was applied, there might be other things which are caught by it, which wouldn't be caught by the Covenants Act in relation to a lease as well. But what it is doing is making sure that if we're going to allow people to assign, they should be subject to the burden. Now, the 2 points of relevance to make of that. Firstly, of course, that it demonstrates the concern of Parliament to ensure that site providers are protected from the effects of assignment, which we'll come back to. The second is that it's redundant, this provision, if paragraph 12.1 means what my learned friend says it means. Because my learned friend says that the effect of paragraph 12.1 is to imprint all of the terms on the agreement. If that were true, then you wouldn't need 16.4 because by taking the code rights, you were imprinted with all of the obligations anyway. And subparagraph 5 is referred to. The effect of that is that you have to give notice of the assignment. Until you do, the assignor remains liable on the covenants. That's effectively what that's doing.
Are they both liable?
Yes. So the only other thing that one needs to be aware of within part 3 is when one looks at paragraph 17 and 17a, because these are dealing with various situations of sharing, they're expressly contemplating the possibility that there will be operators on the site who can use the code rights but are not themselves the parties to the agreement. They're not the person on whom the right was conferred or to whom they've been assigned. My Lord, having skipped back to part 3, I'm now going to skip over part 5 because that's the key part and take you to part 6 finally in my exposition of the general parts of the code. Part 6 deals with what happens after the agreements have come to an end, effectively, or didn't exist. And this is where we now find the original kind of security that existed under the old code, which was the only kind of security under the old code. As we'll see in a moment, under the new code, there's 2 forms of security. There's the preservation and continuation of agreements, and then there's the status of irremovability, qualified irremovability, which is created by part 6. And effectively, part 6 kicks in, if one looks at paragraph 37, it's the right to require the removal of electronic communications equipment. And paragraph 37 effectively says that it applies either because the landowner isn't bound by the code rights, has never been bound by the code rights in question, or they've ceased, or they're not being used and there's no reasonable prospect they will ever be used again. So 37 tells you when they apply. 38 deals with enforcement by neighbours, which we can ignore. 39 is entitled, how does the landowner or occupier find out whether apparatus is on land pursuant to a code right? And that gives the right to a landowner to ask 2 things of an operator. Do you have an ECA on land? Do you have a code right? But that's all. It can't, for example, statutorily require them to tell the landowner the terms upon which they were assigned the code right.
Did you indemnify your asset?
Correct. Okay. My Lord has the point, exactly. And the penalty for that is effectively a costs penalty later on if you don't answer it. So the process of removal is actually in paragraph 40 onwards. And this time the landowner has to give notice requiring removal, and it can also require restoration of the land, which is in subparagraph 2 of 40, which is page 441. And then paragraph 44, very unhelpfully, says the period specified has to be a reasonable one. So if you're unlucky and you don't, since there's no guidance on what is a reasonable period, if you specified a bad period, your notice will be bad. But then after the service of the notice, you can, if you wait 28 days, you can apply to court for an order. The court has a range of orders which it can make to remove them. And effectively, the court can take steps to ensure that the equipment goes, is the long and the short of it. The final point to make, however, is subparagraph 8 at the very end. On an application, under subparagraph 6 or 7, the court may not make an order in relation to apparatus if an application under paragraph 20 has been made in relation to the apparatus and has not been determined.
Sorry, where are we?
Sorry, page 442, my lord, subparagraph 8 at the very bottom. And what this provision is doing is saying, even if the landowner makes an application for the removal, having served the notice, if the operator has, by the time the court decides it, made an application to court for a new agreement, that trumps the application for removal until the new agreement application has been dealt with. So effectively, the warning off process is, I serve a notice on you to remove your mast from my land, and then you can wait indeed until you have to make an application, but as long as you have made an application for it, by the time the court comes to deal with it, the court can do nothing. So if you want to stay on the land, you'll go back into Part 4, and of course Part 4 allows you to go on the land unless the balance of prejudice, and unless you want to redevelop. So before we get to Part 5, there are 3 points to note at this stage. As my Lord Justice Fancourt decided, Mr Justice Fancourt, forgive me, decided below, observed below, this is a statutory scheme which is overlying a contractual landlord and tenant law. It's not replacing it. And the scheme assumes that the law or contract is applying unless it's adjusting it in some way. And it's obviously drafted in a way which is intended to be consistent with the concepts of landlord and tenant and indeed contract law. For example, who might be called a party to the agreement. The second point which my Lord made was that there's a clear distinction in the code between code rights and the agreements which confer the code rights. He also observed that the code was distinguishing between those who have the benefit and burden and those who are parties to the agreement. And we can see that, of course, because one operator may have ECA on site and be exercising effectively code rights by an agreement with the person who's actually got the code rights vested in them. And that is, in fact, On Tower's business model. And the code recognises that. And the code protects those operators in a number of ways. Part 6 that we just looked at, the removability, but also if they need some more rights for themselves, they can apply under Part 4 themselves. So with that introduction to Part 5, we now come to Part 5 itself, which is entitled Termination and Modification of Agreements. Paragraph 28 is on page 418 and is introductory, but if we could go to paragraph 29. This deals with the agreements to which this applies. 29.1, this part of this code applies to an agreement under Part 2 of this code. And in answer to the question that was made before, because a subsisting agreement is deemed to be an agreement made under Part 2 of the code, this provision applies, therefore it's Part 5 applies. Subparagraph 2 is just switching off Part 5 in relation to 1954 Act tenancies and the equivalent in Northern Ireland. So that deals with 2 to 4. Paragraph 30 over the page is the one which continues the agreement. Subparagraph 2 applies if a code right is conferred by or is otherwise binding on, so those are the two things that the code is dealing with, conferring of rights and making those rights binding on other people. A person, the site provider, as a result of a code agreement. So a site provider is actually defined as someone who is either the conferred on or has the rights binding on them. And under the terms of the agreement, the right ceases to be exercisable, or the site provider may bring it to an end. So this is determinable or agreements which would expire. And then 2 says, where it applies, the code agreement continues, so that the operator may continue to exercise the right, and the site provider continues to be bound by the right. So the continuation operates not at the level of the rights, but at the level of the agreement. So the continuation is of the benefits and the burdens of the agreement, although the function of it is to allow people to continue to exercise the rights. It will be noted that unlike the 54 Act, occupation of the site by the occupier is not a criterion. Occupation is not mentioned anywhere in Part 5.
You talk about benefits and burdens. Where's
Yes.
that reflected in paragraph 30?
It's not, my lord. It's reflected in the fact that it's the agreement which is continuing. So otherwise, what
Because
you
the
would
focus
have,
of subparagraph 2 is that the operators can continue to exercise the right,
yes, my lord.
and the site provider continues. So the focus is very much on code rights there.
It definitely is, my lord. But the way in which it does it is by continuing the code agreement. Obviously, the statutory purpose of the code is to allow people to exercise code rights. We see that from the very beginning. It's about code rights, and this is the mechanism which deals with code rights. But the effect of it is to continue the code agreement in relation to, and that, of course,
Is your point about occupation basically saying the assignor is still able to invoke this even though they are not the operator in occupation?
yes, absolutely, my lord. So the code right continues even if the site is temporarily empty, or if the person who's the only person on the site isn't the person with whom the agreement is vested. The function of continuation is to allow someone to exercise code rights, but it does it by maintaining the contractual relationship between the parties who created it or into whom it is for. It doesn't state which operator it's actually talking about in that context. One notes, the operator may continue to exercise the right, the site provider may. Now, my learned friend says that must be the operator in situ with the benefit of the rights. Well, it may be, it is definitely talking about somebody who can exercise the code rights. Actually, it could be a range of operators in that situation, because one party might be exercising the right to have equipment on the site. Another operator, for example, On Tower, might be exercising the right to lop trees, which is one of the common rights which is in one of these scenarios. So a code right in a situation where you have, for example, On Tower providing equipment and allowing EE to have an aerial on its mast, EE will be using the code right to have equipment on land, and On Tower will be using the right to chop trees down to make sure it doesn't block, or it may be giving that to EE, who knows.
If I've got a code right to have equipment on the site,
Yes.
am I still exercising that right if what I have done is assign the right to have equipment on the site to someone else who puts their equipment on?
No. If the right has been assigned to somebody else, that person is doing it. You can share the right by effectively not assigning but allowing someone to use the right, which is what is commonly done. But that's not an assignment of the right as such. And of course, it would be common, and is common, for the ability to share the right, to use the right, as it were, to be shared with more than one operator, because often these masts have got several people using them.
And just going a step further, if you have shared the right, even if as it happens you've taken your own equipment off, but the person you're sharing with it had their equipment on, would you say that was still exercising the right?
Potentially, you'd be still exercising the right, we would say, yes. Turning to paragraph 31 then, my lord. 31 deals with termination. A site provider who is a party to a code agreement may bring an agreement to an end by giving a notice in accordance with this paragraph to the operator who is a party to the agreement. So here we have the first relevant mention of parties to the agreement in the code. And what it is confining the person who can serve this notice to a site provider who is a party to the agreement. And it's identifying the person to whom that is to be served. It's the operator who is a party to the agreement. So there's a distinction with paragraph 30, which is only identifying site providers and operators. The notice period is that has to be given in one of these is 18 months, which we see in 31(3)(a. We'll see how the provisions then operate subsequently, but that gives you some flavour of the potential prejudice to a site provider who doesn't know who the relevant operator who's a party to the agreement might be. That's one of the elements of that. And then if we turn to 31(4), we give the limited grounds upon which a site provider is allowed to serve one of these notices. So the agreement continues indefinitely by virtue of paragraph 30, and there are only 4 grounds upon which a site provider is allowed to terminate. The first one is substantial breach of the obligations. I'm just reading that. As a result of substantial breaches by the operator of its obligations under the agreement. So which operator is being talked about, and as my Lord Justice Fancourt observed, it must be the operator who's been mentioned earlier in the paragraph, which is the operator who is a party to the agreement. So it's contemplating that the party to the agreement may breach the obligations under the agreement. B is the equivalent provision for rent, persistent delays in paying rent. C is redevelopment. And so one of the ways in which you can terminate, or indeed avoid renewal, is by invoking your right to redevelop. And then D is because the paragraph 21 test, the public benefit test that we were talking about before, is no longer met. So essentially the difference between those two elements of part 5 and part 4 is that in part 4 they have to be raised in the proceedings. In part 5 they would have to be raised by the site provider by serving a notice in response to an attempt to renew by my learned friend. But they arise in each case. Now, redevelopment and the paragraph 21 test, we will see in a moment, are not mentioned in the provisions for renewal and modification, which we'll come to. But the way in which this works is, if you are APW and On Tower makes an application to renew or modify, you respond to that application with a notice to terminate on the basis that you want to redevelop, or because the public benefit test is not met. And then those two applications proceed, and the court will deal with those in the sensible order which deals with that. So that's how it arises within the renewal process. Paragraph 32 deals with the effect of the notice.
I'm sorry if I've missed something.
Yes.
Paragraph 31 starts off with the words "a site provider." Is that term defined somewhere?
Yes, my lord. It's in the previous paragraph 30. I read it to you.
Oh, there it
I didn't
is.
point it out.
Yeah,
in A.
Thank you.
A code is conferred by or is otherwise binding on a site provider.
Yeah, thank you.
So a site provider isn't somebody who is conferred or is simply bound by the rights. Something beyond that in that situation when you're on the site provider side. So I was in paragraph 32, my lord. Paragraph 32 effectively deals with what happens to a termination notice, and effectively the operator has to give a counter notice within 3 months, and then the operator has to bring the claim in relation to that within a further 3 months. So it takes 6 months to get to a court potentially. The notice itself being an 18-month notice. And then at subparagraph 4 at the bottom, if the grounds are established, then the court must terminate the agreement. But if not, in subparagraph 5, you end up in paragraph 34. And those are as we'll come to see, those are the court's powers for renewal and modification. So if you start the process of termination and you fail in relation to that, you end up in renewal and modification anyway. I observe in passing, my lord, that neither here nor anywhere else in the code do you find any statutory process for operators to terminate code agreements. However, everybody seems to accept that operators must be able to terminate agreements, although it's not entirely clear how they do so, because otherwise they'd run on forever.
They would run on forever, would they?
Yes, because they don't come to an end because of paragraph 30.
No, I see.
Your Lordship begins to see why Lady Rose's comments are so often stressed. Paragraph 33 then, my Lord, is modification. How may a party to a code agreement, note that it's in the heading, require a change to the terms of an agreement which has expired? An operator or site provider who is a party to a code agreement by which the code is conferred or otherwise binds the site provider may, by notice, in accordance with this paragraph, require another party to agreement to agree that, and then effective its modification, addition or subtraction of a code right, provided that someone is bound by an additional code right, or termination and replacement. So although 33(1)(d) raises the possibility that an operator could apply for termination, it's only in the context of replacement with a new agreement. In this context, without taking you through the provisions, the notice has to be 6 months. And I should have pointed this out in relation to termination notices, but it's true of both sets of notices. You can't use these provisions until the contractual terms have already expired. That is another situation in which an operator might require to use Part 4. Because it's got a contractual agreement, it wants another code right. If the agreement had expired, it could apply to modify it to add the code right. But if it hasn't expired, it has to apply for a new right under Part 4. And that was explicitly held to be appropriate by the Supreme Court in Compton Beecham. So these provisions require that the notice specify 6 months expiring after the contractual term has ended, but you have to wait 6 months before the application is issued in this context. So it is actually theoretically possible to get into a renewal, I suppose, more quickly by the site provider having tried to terminate it, because the operator's actions have to occur within 3 months, and then again within 3 months, but he could do it on day 1 and day 2, serve a notice and then issue the proceedings. And then if the site provider gave up, then on day 3 the court could decide the renewal process in that situation, I suppose. And then paragraph 34 deals with the orders which can be made. So we've already dealt with the termination, which is elsewhere, but 34 is the court's powers when we're into the renewal and modification process, either because of an abandoned termination or because of an express commencement of a renewal modification application. And as you'd expect, it has all of the powers which are referred to before. And my learned friend so just actually dealing with that menu briefly, paragraph 2, it can just continue the agreement for a defined period. All agreements, you'll remember, have to have a term to them, but it can continue it for a finite period. It can modify under paragraph 3. 4 and 5 are the additional discharge of code rights and making other people bound by them, and 6 is replacement. And then 7 just makes it clear that the existing agreement will continue until the order which is made takes effect, rather like the 54 Act. 8 makes it clear that the new agreement's also a Part 2 agreement. And then 10 allows the court to specify the terms. 11 brings us back into Part 4 for various purposes, for example, consideration and compensation considerations. 12 requires the court to have regards to the existing terms, rather like the 54 Act, but in fact not like the 54 Act, as the court ultimately decided. And the 54 Act, the person trying to change the terms of the original lease under a renewal has to justify a change. But that's not the case, well, not quite the case in the same way under this Act that the court has held. In 13, and this is a provision which is predicated by my learned friend. It says, in determining which order to make under this paragraph, the court must have regard to all the circumstances of the case, and in particular to the operator's business and technical needs. So by the time we've got into court, my learned friend says, the court must be looking at the business and technical needs of an operator, and that must be the operators who has the benefit of the code rights, he says. And in short, in relation to that, we say that's not necessarily true. It can be the benefit of any operator. For example, in the scenario where I gave you, where On Tower's clients, say EE or H3G, are on there, their technical needs might be required in relation to it. And even if the operator means what my learned friend says it means, which means it must be the person who's making the application in this particular case, and therefore it must be the respondent or applicant in this case must be the person with the benefit of the code rights, which is how he puts it, as it were. It also refers to all the other circumstances. So the power is still broad enough to be able to deal with everybody, even though in the paradigm case, it's expecting to deal with the person who has everything vested in them. Fair enough.
I mean, in terms of the not all the circumstances point, the prior point, when it says the operator, does that not suggest the person applying?
Yes, it suggests the party to the agreement, exactly. Which would, on our case, would be the person with the benefit or the burden of the agreement. He says that must mean that what it's focused on is that the party to the agreement is the person who actually needs the agreement, which means that the party to the agreement can't have stayed with the assign all. That's the way in which it gets to the point. Because otherwise you'd be looking at the wrong person's technical needs. We say, well, a paradigm case, you would expect that case, but in fact the clause is broad enough to be capable of dealing with that situation as well, because it deals with all the circumstances of the case, even if it's drawn on the assumption. But we say the code does work on the assumption that the person in occupation will be the party to the agreement, because it's working on the assumption that the burdens of these agreements will be passed, because that's what should happen. It's not appropriate that operators take the benefits of these rights and are allowed to exercise them under a statutory scheme without submitting themselves to the burden. That can't be what Parliament wants to occur. Paragraph 35 deals with interim arrangements. Effectively, once you're into this regime, either party can apply to modify pro tem anything, and indeed to fix the interim rent, rather like the 54 Act, so that the interim rent moves from the beginning of the agreement. So 2 points to highlight, one of which I've already highlighted on part 5. Then the first one is there's no power for operators to terminate anywhere. And secondly, as I've already highlighted, there's no mention of occupation anywhere. Consistent with the fact that there may well be operators on the site who don't have their own rights under this agreement, they might have rights under another agreement. And it's consistent with On Tower's own business model of providing services to other people who are actually the ones who are exercising them by putting masks on them, or partially exercising by doing so. And then, my Lord, what I hope are 5 uncontroversial propositions. 6, my Lord, not 5. I've added one without changing my heading, I apologise. The term party to the code agreement is undefined by the code. The second one is, it's seemingly agreed by everybody that On Tower is not actually a party to the agreement in the normal meaning of that term. I know that that's something which everybody understands, my Lord, and the court will forgive me if nevertheless I invite the court to look at the authority which both parties have pointed to for that, the paragraph, because it is, in my submission, a useful reminder. It's in the authorities bundle behind tab 6 at page 131. The facts of the case really don't matter, my Lord, but I can take you through them if you wish. But effectively, it's about whether or not an assignment under an agreement which dealt with the provision of insurance premium advancement to an insurance broker was assigned. It really doesn't matter, my Lord. But paragraph 44 is in the judgment of my Lord Justice Aikins is the reminder. As a preliminary remark on this issue, it's important to recall the effect of an assignment of a right, whether or not it's a statutory legal assignment. The assignee becomes either the legal or beneficial owner of the thing in action and its benefits. He does not become a party to any contract or deed which contains or gives rise to the right. In the next sentence, my lord, the assignee will only become a party to the contract or deed if there is a novation of the instrument containing or giving rise to the right. You may wonder why novation is not mentioned anywhere in this case. And the reason for that is it doesn't suit On Tower to say novation anywhere in this thing, because the novated agreement, of course, is a new agreement. It then wouldn't be in writing and signed by the parties. So it wouldn't be a code agreement.
How far can we assume, though, that the code is tracking contractual terminology in its strict sense? For example, para 16.4 talks about assignment, which carries with it burdens, which is not what assignment means in the law of contract.
My lord, I entirely agree. People talk about the assignment of agreements all the time, and they don't. It's not. If you use that in a legal, in this paragraph, you can't be meaning assignment of an agreement because it's not possible. So you can't be.
But I'm just right. Everyone is assuming that Lord Justice Aikins' sort of contractual definition of what it is to be a party isn't met. But there's a hidden premise there that the statutory definition intends to, subject to certain adjustments, track the standard contractual definition.
My lord, yes and no. There is a hidden, in my reference to this, there's a hidden assumption that that's the starting point, but it's quite clear
It doesn't end.
that the statutory regime is intending to modify the contract law. And we know that, first of all, because paragraph 10 specifically defines some people to be parties to the agreement in those circumstances. We also know that, as your lordship points out, it's talking about the assignment of agreements, which is a non sequitur actually, although it's commonly an expression which is commonly used in the law. It's not actually legally.
And then we have Lord Justice Newey's.
Yes, my lord. And then we have Lord Justice Newey. So it's not tracking it, but it's starting from the proposition. That's why I stressed, my lord, Mr Justice Fancourt's reference to the fact that this is a code which overlays and supplements and alters in some respects the contract law, but you start from the contract law and move outwards is what we say in relation to that. But the reason I introduced that was the point, just as a way of introducing the point about novation. You may be wondering why novation is not relevant here. The reason why novation is not relevant here is because my learned friend can't say the agreement's been novated by the conduct of the parties. Well, if he did so, he wouldn't be a code agreement anymore. It would be a new agreement which wasn't in writing.
16.4 follows the law,
Yeah. So the third proposition, my lord, we've just touched upon is that the code deems people to be parties to the agreement which are not. And the fourth proposition is that paragraph 10 is not exhaustive, and we have that from GenComp. The fifth proposition is that it must be possible for new site providers and operators to replace the existing ones as being those who are treated as parties to the agreement in some way.
Sorry, can you say it again so I can get it down? Must be
Yes,
possible
Lord. It must be possible for new site providers and operators to replace the existing ones as being those who are to be treated as parties to the agreement in some way. And the sixth proposition is that it can't be enough that you are merely enjoying the rights in some way to be a party to the agreement, because the code is covered with references to the sharing of rights, and it's inherent in all of this that there can only be one party to the agreement at a time. I think everybody seems to accept. So, it follows from that that there must be a test for when you should be treated as a party to the agreement. What is it and where do we find it? And our answer to that is we find that answer in GenComp. Even though it's not dealing with this specific set of facts, this specific scenario, it leads you to the answer. So, my lord, next I will take you through GenComp, if I may.
Just before you do, you say, and I'm sure you're right, that it's accepted that there can only be one party to the agreement.
I'm sorry, my lord.
Sorry.
Party to the code agreement, my lord.
Yes.
For the purposes of paragraph 33.
Yes.
That's been our position. It's recorded by my Lord Justice Fancourt as being the position. I don't understand my learned friend to be differing in relation to that.
No. So just thinking that through for a moment.
And of course, just thinking that through, my lord, there is the possibility, of course, that you will end up in a scenario where a code agreement, one right under a code agreement has been assigned, because there's nothing to prevent, as far as I can see on the wording of the code, prevent the choosing action inheriting one right to be assigned to an operator without the other rights leaving in that situation. That would be a very good reason why you would treat the original party as continuing to be the party to the agreement in that situation, since they were the party who had the benefits, and they were either the original party or they were the last party who had the benefits and burdens of the agreement.
Yeah.
Law of contract wouldn't restrict you, though, would it, to having one person party to the agreement capable of benefiting from rights? You could have joint promisees on one side, for example, any one of whom
yes, my lord.
to perform the burdens. But you're saying this is another way in which the code departs from.
No, my lord, I'm thinking of the paradigm case where it's the party to the... I accept there's also... The code doesn't really deal with the situation where you have a tripartite agreement where where different code rights are being granted to different parties under the same agreement. Or...
Yeah, one of whom may not owe contractual burdens, depending on how the agreement is.
The code just doesn't deal with that situation at all. And I think the reason for that is fairly clear, which is that it's dealing with effectively operators who are singular and have a right to do things as operators in relation to it. That's how it's arising.
It's not how it works on the ground.
It's not how it works on the ground. They haven't provided for it.
So just following it through from a moment on, your solution to all this, you say, well, where there's been an assignment, the assignee becomes the party to the agreement if they enter into a covenant.
If they do something to bind themselves to comply with the obligations, the most obvious way of doing that being to enter into a covenant.
So until that moment, the original party, or I suppose some intermediate party who's given the covenant, is the other party to the agreement.
For the purposes of paragraph 33, exactly.
When they give that covenant, they cease to be the party.
Yes.
And the person giving the covenant becomes the party.
Yes. So once all the benefits and all the burdens have moved, the status of party to the agreement moves.
When you say all the burdens have moved, has the burden moved? Why has the burden moved off the original contracting party?
I accept that point, my lord. You have always to adopt some purposive approach to the agreement, and you will always have to do that because paragraph 31.4 deals with breaches. 31.4, yes, deals with breaches by the person on whom you're serving a notice of the agreement. So, in all circumstances, you have to do something which treats the person against whom you are subjecting a termination notice as being subject to obligations which they are breaching. And we say the way you do that is by reading the party to the agreement as being someone who has the benefits of the agreement and who has adhered themselves to the burdens of the agreement in some way, so that they can be treated for all purposes of part 5 as the relevant party.
But in the Paris 16 world, which we're not in,
the problem never arises.
you'd have dual liability until the notice is served.
You wouldn't, my lord, because the benefits would have passed. So if one has a transfer to which paragraph 16 applies of a contract, so we're not under the Covenants Act. In that situation, the effect of the assignment would be to transfer the benefits.
Sorry, the burden would remain. Well, it would remain on the hook until you gave your notice.
Correct, but the only person with the benefits and the burdens would be the assignee. So although there's joint liability for the burdens, the benefits and burdens only sit in one party.
But if I give the deed of covenant as the assignee with the benefit, I enter into a deed of covenant. By what mechanism does that bring to an end the burden liability?
It never does.
It doesn't. They remain liable.
They do, my lord. A point which I'll refer to later on. I'll deal with it when my learned friend talks about his scenarios in relation to how the benefits and burdens are moving and how this can't be right. it's important to bear in mind that the original contracting party, and indeed anyone who's given a covenant in the meantime, unless it was a covenant limited for what their period of occupation, will still remain liable on that obligation. But that's a feature of the contract law. That's just a feature of this.
But to be clear, you say that at the point where someone else acquires the benefit and burden, the person who actually is a party to the agreement, namely the original contracting party, ceases to be a party to the agreement for the purposes of this.
Yes. Yes, my lord. And that's really in order to ensure that there's only one at a time. I mean, on my learned friend's case, it's still the same issue. He says you only have to have the benefits passing. So you either accept that in that situation, if he's right, you have two parties to the agreement, or you have to pick one.
So they cease to be party for the purpose of the code, but as a matter of contract.
Yes.
They remain
Yes, my lord.
Thank you.
And just pursuing it a moment longer, if you follow the paragraph 31 process, so the site provider can bring the agreement to an end by giving notice to the operator who is a party to the agreement.
Yes.
Ex hypothesize the original contracting party would be an operator.
Yes.
Um,
And they're definitely, in contract law, a party to the agreement.
definitely party to the agreement. But if you're not careful, you have to give notice to all sorts of people because, well, at least more than one person.
Unless you say it's one, yes.
Yes, I see.
There's nothing in the code which stops someone explicitly being a party to the agreement if they ever were. So you have to read that in somehow into the code.
Sorry, this is quite an interesting rabbit hole we've gone down. Under para 33,
Yes, Mum.
if you're changing terms, are the terms you can change then those of the covenant with which the assignee has signed up to without changing the terms that would apply as a matter of contract so far as the obligation is still owed by the original assignee are concerned? Or do you think to change?
Well, we would say that the thing that the way that someone binds themselves is by adhering to giving a promise effectively by deed, so you don't need consideration, to the site provider to perform the obligations of the agreement. You then change the obligations of the agreement by modification through this process.
And I mean, let's say the change is conferring an additional right
Yes.
on the operator. Is that conferred on the...
Why not? They have the benefit. They've been assigned the benefit of the agreement, so why can't you?
No, is it conferred on the original?
Oh, I see.
If it's that agreement, if what you're doing has the effect of changing the terms as well in contract between the site provider and the original assignor.
It's a good question, but it's the same problem, whatever the outcome of this, isn't it? Because the contract law is always there.
This is
They won't get the benefit. We say they won't get the benefit of it because the order will confer the benefit on the person who's the applicant.
Yeah.
But I mean, one of the points that we pray and aid is that it should be the person who has the burdens in relation to this, or is subject to the burdens, who is the person who's allowed to fiddle around with those burdens in relation to this. So if On Tower isn't subject to the burdens, they shouldn't be the one who's entitled under the statute to modify those burdens, and those burdens are the ones which have to be performed by someone else.
So I'm probably being stupid here or not capturing fully the discussion. So under 33, no, I'm backtracking. I won't pursue this at the moment. Yeah.
My lord, I am about to move off the code into general.
Well, actually, no, I'll pursue it a longer. So the site provider requires the other party to the agreement to agree modified terms,
Yes.
higher rent.
Yes, my lord.
So how does that work on the original contracting party?
Well, in practical terms, what you might say is that the court in those circumstances says, I'm not going to increase the rent under the old agreement. I will use one of my other powers, for example, to replace that agreement with a new agreement which binds these actual parties and which increases the rent. So the court has got the power to avoid creating these problems. I accept, my lord, that the code in no way answers any of these questions. There is a practical way in which the code can be operated so they don't arise.
There's a workaround. Basically.
There's a workaround. But my lord, there is a difficulty around created which isn't worked around if the person applying is modifying obligations to binding on other people and between different people.
Yeah. You were moving off the code.
I was moving off the code, my lord, will be relieved to hear, or at least to a discussion of the code. In GenCom, my lord, which your lord finds in the first bundle of authorities, tab 11. I suspect that the court has all read the decision, but just to remind you, this was a code lease, which is quite important. Vodafone, after the code lease had been created, Vodafone was the original lessee was granted a lease in 2003, and in 2018, APW was granted an intermediate lease by the landlord. So it became Vodafone's immediate landlord. Paragraph 10.3, as we saw, deems successors in title of the original party who granted the code agreement, deems them to be a party to the agreement, but nobody else. So not, for example, someone with a derivative interim lease. The operator, Vodafone, therefore sought to avoid dealing with its rival APW and went to the original landlord over the head. It said, you're not a successor in title, so you're not a party to the agreement, so I have to deal with the person who was the party to the agreement, the original party. Now, the operator won that in the Upper Tribunal because the Deputy President, Martin Roger, held that 10.3 was clearly a closed list of people who have been deemed to be a party to the agreement, and so you lose. And despite a load of friends' valiant efforts to argue, so it's not a successor in title if you're an intermediate lessee. So they couldn't be a party to the agreement. The Court of Appeal reversed that decision. The substantive judgment is that of Lord Justice Newey, with whom my Lords Lord Justice Lewis and Phillips agreed. They agreed that APW wasn't a successor. They held that as a matter of language, it wasn't clear that 10.3 was a closed list. They held that the statutory scheme required that the parties, from time to time, who had the benefit and burdens of the agreement, be treated as parties to the agreement. APW had the benefits and burdens of the agreements because of its status, and it was therefore standing in the shoes, a phrase that's used by the Law Commission, as we'll see, and adopted by the court, of the original lessor. If I can take you through the judgment, my lord. I hope this is useful, but I'm not actually sure how else to make the submission. So, paragraphs 54 to 57 effectively spell out the consequences of being a party to the agreement. And then, having been through those, my lord, paragraph 58 said, this all makes sense so long as A and B, A being the original grantor and B being the original grantee in this judgment, remain the occupier or site provider and operator respectively. But code agreements are intended to be long-term agreements, continuing despite the expiry of the contractual terms. That's obviously the new code, not the old code. And capable of surviving both a change of site provider and a change of operator. One would expect that the provisions of the code which depend for their application on a person being a party to the agreement would also be capable of continuing to apply despite changes in the identity of the site provider and operator. Paragraph 59, he then analyses the consequences of a change in the operator, and he notes that in the course of this paragraph, he notes that paragraph 16, which we've looked at, prevents the exclusion of assignment. And then he points out that this is the recommendation of the Law Commission. And he notes that the Law Commission said that by assignment they mean simply a case where one code operator comes to stand in the shoes of the other operator. And we'll see that again. So that's what they were intending. And you will note also in that paragraph a bit later on, my Lord quoted the sentence which says, a change of code operator in itself should in most cases be immaterial to the site provider. So just standing back there, what seems to be being contemplated by the Law Commission is that Parliament should allow assignments of these things and facilitate that on the basis that it doesn't matter to the site provider that the operator has assigned. That's the basis of it. And my Lord, although I've just opened GenComp, I think it would be useful at this stage to show you what the Law Commission did say about this, rather than simply relying on that summary. So my Lord, because they're in different bundles, I hope you'll excuse me, but the Law Commission report, there was a consultation and then a report. We might have to look at the consultation in a minute, but the report begins at 480 in tab 19. If I can invite you first of all to find paragraph...
Can you give the page again?
Yes, it begins at 480, my Lord, but I'm actually inviting you to 485.
Thank you.
This is entitled Assignment to Code Rights. And the first point which is made by the Law Commission is the one that my Lord just made. The 2003 code treats code rights as initially bipartite, conferred on occupier. Essentially that's not changed much, but effectively the paradigm situation is one-on-one. And paragraph 3.5, the commercial and corporate world of the code operators has moved on and their business structures have evolved. There have been many instances of one operator taking over another one's business or merging or wishing to assign agreements to subsidiaries and so on. Note the reference to assign agreements. The Law Commission really should know. And makes no allowance for the addition or substitution of different business entities. So it points out that there is nothing in the old code dealing with assignments. And your Lordship might reflect on that when you come to consider whether or not, as is suggested by the other side, paragraph 2.5 of the old code, replicated in 12.1 of the new code, was intended to imprint the burdens on successive operators, given that the Law Commission says nobody ever thought about an assignment under the old code, so that can't be what it's doing. My Lord, if we then come to the discussion and recommendation section at 488. In 316 says that we begin by making it clear that we recommend no provision that might change existing agreements negotiated and priced on a particular basis, and what follows we refer only to agreements entered into and code rights created after the introduction of the revised code. So it's dealing with the new regime. We also distinguish assignment from sharing. In discussing assignment, we mean simply the case where one operator comes to stand in the shoes of the other operator, not where a second operator joins the first in the site. And then going
pausing there.
Yes.
They're not making a technical point about not being able to assign agreements.
No, they're not. But what they are doing, we say, is making a more general, practical point about one person standing in the shoes of another person. And we'll come to what it means to stand in the shoes. But we say you don't stand in the shoes of another person vis-a-vis the site provider in a situation where the second person's relationship to the site provider is fundamentally different to the first one.
Where you're having a sharing agreement, will that frequently involve indemnity provisions of some kind as between the entities?
Between the operator who has the benefit of the agreement and the next party, I have never seen one, my Lord, so I don't know.
You're a mystery.
Actually, I'm not sure I haven't ever seen one. I think I probably have seen one. Now I think about it, but I will change my answer to I don't know.
You'll see more than I have.
So 318 makes the point that the corporate bodies change, etc., and things move on. Paragraph 319 We are impressed by the arguments of the code operator to the effect that assignments may be necessary for external reasons. It's arguable that in these circumstances, the assignment need make no difference to the site provider and should not be prohibited, nor made subject to a price. We distinguish that proposition clearly from situations where code operators amalgamate, seek to pay one rental where previously they paid two, or where code operators wish to assign some but not all of their rights on a particular site, etc., etc. We address those, so as to achieve sharing, we address those separately below. So that's how the sharing is kicking in. So it's talking in assignment very clearly, when it's talking about assignment, it's talking about one change of entity being replaced by another entity. Assignment conceived of narrowly in this way and contrasting with sharing should not be a means of landowners extracting a profit. Changing code operator in itself should in most cases be immaterial, and that's where the word immaterial pops up from in GenCom comes from. And then 321, we note consultees' concerns that the site provider may not be satisfied that the assignee is in the financial provision to take on and perform the statutorily the code operator's obligations. And that's the paragraph which then says, so we will allow assignments still to be subject to the provision of a guarantee. And then 322...
Sorry, can I just read it through?
Yes, my lord.
Yeah. And then
3.22, the revised code will need to make specific provision as regards the assignment of other agreements conferring code rights in order effectively, and other reasons, agreements than leases is what's means, in order to effectively to pass on the burden to the assignee. For example, the code operator to whom a way leave is assigned should be responsible for the payment of rent for the period after the assignment, not the assignor. Now it's dealing with, I accept the point that it's dealing with the future. But, my lord, it's quite apparent from all of this what Parliament is intending to facilitate and what it is happy to allow in these situations. One standing in the shoes of another in circumstances where the other one, from the site provider's point of view, the change in identity has been immaterial. And that's all given effect to in relation to future agreements by paragraph 16 of the code. And for good measure, that is all confirmed, well, it's confirmed by the somewhat laconic explanatory note, which one finds at 464 to paragraph 16. So it's laconic, it's reasonably long, I suppose. So the first sentence is the one upon which I rely. Paragraph 16 provides that an operator may assign an agreement under which the code rights are conferred to another operator, enabling the second operator to stand in the shoes of the first.
You don't get a lot from that, really.
You don't, I don't, my lord. I simply say that what it tells you is that these are the provisions which are doing the thing which the Law Commission was saying should be done for the future. That's what you get from it. So, my lord, if we return to the decision in GenCom, we were in paragraph 59, and then in paragraph 60, my lord considers the change in the operator. My lord, can I just invite you to read that paragraph? So my lord sees that Lord Justice Newey was specifically equating coming to stand in the shoes of as involving burdens, because he goes to some length to point out how you would stand in the shoes, at least contractually speaking, only if you had the burden. That's what he's explaining in this paragraph. And then in 61, my Lord considers whether such an assignee, as is the word used, i.e. one who's had the benefits and the burdens, should therefore be treated as a party to the agreement. So paragraph 61, what however is conspicuously missing from the code, either in paragraph 16 or elsewhere, is any provision equivalent to that in 10.3, that such an assignee, i.e. one with the benefits and burdens, is to be treated as a party to the agreement. But it cannot seriously be supposed that after an assignment by B to C, C is not a party to the agreement for the purposes of the code. Take, for example, the case where C commits substantial breaches of his obligations under the agreement, or persistently delays in paying payments to A, or wishes to redevelop. If C is to stand in the shoes of B, and if the assignment to C is to be something that is generally immaterial to A, one would expect A to be able to serve a notice on C seeking to terminate the agreement, such as A would have served such a notice on B, and B had still been the operator. But A's right to do this, blah, blah, and then it continues to look at 31. So my Lord again explicitly saying it's appropriate that someone who has had the benefits and burdens transferred to them should be treated as a party to the agreement. Because, for example, it's important that their breaches might need to be considered. And of course we have the point about the coherence of paragraph 31.4 and the references to breaches in the termination notice.
Just sort of thinking on that for a moment. If it's a lease and the Covenants Act means that the original lessee is relieved of the obligation,
Yes.
then when there's a breach, it's only a breach by the person who now has the burden.
Yes.
If you had a situation where the Covenants Act didn't bite, the failure to pay rent or whatever would be a breach by anybody subject to the burden, which could be the original contracting party as well.
Yes, but the obligation not to do something, for example, which was done by the new party, wouldn't be. An obligation in the agreement not to do X and Y would be.
Yeah.
So in paragraph 63, my Lord, I think this is referred to somewhere in Maloney Friends submissions or possibly at an earlier stage in the proceedings, but the fact that the court noted that it was common ground that an assignee operator would be treated as a party to agreement. That's obviously on the basis that they have the benefits and the burdens, and it was in a leasehold context in that situation. And then at 64 to 66, my Lord considers, by analogy, the scenario of a change in the site provider. And at 64, we see, against this background, we can now consider the case of whether it is a change in the site provider rather than the operator. What one would expect to find is that just as A can exercise code rights against both B and if the agreement is assigned C, conversely, the operator, B, or as the case may be, C, can exercise code rights against both the original site provider and someone who steps into their shoes. So effectively, it's a mirroring point which is being made. And at 66, over the page, my Lord, the first complete sentence. And just as the assignee of the agreement who acquires the benefit and burden of the agreement, i.e. C, is to be regarded as a party to the agreement for the purposes of paragraph 31 and 33 of the code, so one would expect that the transferee of the freehold who takes subject to him with the benefit of a lease would equally be regarded as a party to the agreement. So again, it's quite clear that what's being drawn is that the key point is benefits and burdens have passed in one case, and if that must obviously be a situation where you can treat them as a party, so must it also be true in the site provider case. So we're not in this situation because it's not a lease and it's not the site provider we're talking about. And paragraph 67, then this is the paragraph I mentioned to my Lord Justice Holgate earlier on, the explanation of 10.2 and what it's doing. The explanation of paragraph 10.2a is therefore likely to be something else. The obvious answer is it's intended to deal with the case where A confers rights on B by way of way leave. Such an agreement not being a grant of property right would not, under general law, be binding on D, i.e. D is in this scenario, is the assignee of the site provider. D could take the benefit of the way leave but would not be bound to honour it. That would make the operator's rights precarious, which would be contrary to the provisions of the code. The code was intended, in the words of the relevant minister, to provide a robust platform, etc., etc. So it's unsurprising that paragraph 10.2a provides that someone who steps into A's shoes by taking an assignment of A's interest will be bound by the agreement conferring the code rights. So again, saying in order to make the site provider's identity change mean that the new site provider is stepping into the shoes of the old site provider, you have to make them subject to the burdens, and that's what 10.2a did. What then of 10.3, which is the one which deems someone in that situation to be a party to the agreement? And he says, I think it was largely for the avoidance of doubt. We know that someone such as D, who took the same interest as A, would be bound by an agreement conferring the code right, even if it's in the form of a way leave, by virtue of 10.2a. And I think it must have been assumed that D would also have the benefit of the agreement as successor to A. And in such case, therefore, D steps into A's shoes. So again, benefit and burden. And I think that even without paragraph 10.3, it would only make sense if D were regarded as becoming a party to the agreement. And at 69, he then considers the more complicated case of a concurrent lessee. And then 3 lines up from the bottom of that page, one would expect E to be regarded, E is the concurrent lessee in this scenario, to be regarded for the term of the concurrent lease as the other party to the agreement, as during that period E steps into the shoes of A just as much as D does, so just because it has the benefits and the burdens in relation to it. Paragraphs 70 to 74 deal with the question of whether 10.3 is conclusive, which we don't need to look at. And then 75 is the key conclusion, from which I quoted in my opening remarks, my lord. Applying that approach, it seems to me that the regime is intended to work in such a way that the person currently entitled to the benefit and burden of the agreement as operator, and the person currently entitled to the benefit and burden of the agreement as site provider, are parties to the agreement and can exercise the rights conferred by Part 5 of the Code. That can, in my judgment, be achieved by construing paragraph 10.3 as not intended to define exhaustively who is to be treated as a party to the agreement. On that basis, APW, being currently entitled to both the benefit and the burden of the lease by virtue of the concurrent lease, is to be regarded as a party to the agreement, with the result that it can invoke paragraph 31 by relying on, etc., etc. 77 to 86 dismiss various points which were made by the operator in this situation. And we should note in passing paragraph 78, Mr Reed said that the code created a sui generis form of statutory rights, designed to be as far as possible a self-contained code. It was intended to be a unified set of rules that covered all situations from a one-off licence in relation to tree lopping to a long-term full-blown lease. That I accept. The code has to be applied both to contractual arrangements such as licences or way leaves and the grants of property rights such as leases. But I do not accept that this means that one jettisons the ordinary law of landlord and tenant, or as Lord Justice Lewison put it in argument, that the code exists in a legal vacuum. That's one point, my lord. The second point is in paragraph 83. Mr Reed said in argument that APW as a party to the agreement by virtue of having a current lease would not work in the same way if the code rights conferred on Vodafone had been conferred by a contractual licence rather than by way of a lease. And if APW's solution only worked in the latter case, that suggested it was not an ideal solution. I do not think it's necessary to consider what the position would have been had Vodafone had a contractual licence rather than a lease. I accept the answer to this question is not obvious. So the question which is being asked is, well, what happens if there's a concurrent lessee who hasn't taken some of the benefits or burdens in relation to that? But the reason it's not obvious is because it creates the problem of that person potentially not standing in the shoes. So again, it's a reinforcement of the point that we mean. It's not obvious what you want to do in relation to that because the code seems to assume that everybody, successors in that loose term, should be in the shoes of other parties. So the propositions, my lord.
So just before you do, while it's in my mind, another red herring. Just to understand your case. So suppose you have the original contracting party as operator, assigns to assignee 1.
Yeah.
Assignee 1 gets the benefit of the agreement and gives a covenant to comply with the agreement for so long as it has the benefit of the agreement.
Yes.
That means that it becomes
to the site provider, my lord. Yes. It becomes the party to the agreement at that point.
yeah, and then assigns to assignee 2,
Yes.
who gets the benefit of the agreement but gives no covenant. Who is then the party to the agreement,
Assignee 1 being the last person who had the benefit and burdens of the agreement.
even though it no longer has the benefit.
Yes, because they still have the burdens, and they were the last person to have the benefits and the burdens. Why should they, if they have chosen to assign it away in a situation where they haven't ensured that the burdens have also passed, why should they cease to be treated as the party to the agreement?
And just to be clear, do they have the burden? They've given a covenant to comply with the agreement for so long as they have the benefit of it.
My lord, I said that they were the last person to have had the benefits and burdens. But yes, it's talking about the, I mean, your lordship could disagree and say it's the original party as being the only person, but it would be very odd if the original party became the party to the agreement again in that scenario, having been once a party to the benefits and still the party to the burdens in that situation.
What would happen if I assigned my tree lopping right to assignee number 1 and my equipment storage right to assignee number 2 under an agreement with the site provider that embraced more than one code right?
You remain the party to the agreement, my lord. And the agreement definitely hasn't passed to either of those parties in that situation. It's very difficult to say that they are the party to the agreement, the party to the operator who is the party to the agreement. They are not. So effectively, I mean, this is one of the reasons why, which favours our interpretation of this. Where you have a bifurcation scenario, the code still needs a person to serve things on. It still needs the person empowered to change the agreement in relation to that. If you're bifurcating the rights, you leave it with the last person who had everything.
Otherwise, you'd have to create somehow a split.
Or a regime for working out which of the operators you have to serve and in what circumstances. And does it depend on whether or not you're moderating one right or a right that covers both people, or who do you serve?
So you have to stand in both shoes, not just the left shoe or the right.
There can only be 2 shoes, my lord, I think is how I would say. There can only ever be 2 shoes, and if you create more people than you have shoes, you have a problem.
Sorry, we're going to come to your propositions.
My lord, I can squeeze them in just before
let's do
one
that.
very quickly. I'm not sure any of these will be a surprise, my lord. We say firstly, therefore, the Law Commission and thus Parliament has recognised that substitute assignments must be facilitated. Okay. Second proposition, the code is intended to operate on the basis that where the substitute stands in the shoes of the original parties, so that it is generally immaterial to the other party, they are to be treated as a party to the agreement. That's all in Gen Comp, my lord, and none of it is overture. It's just that it doesn't consider this situation. I say that because at various points the word overture has been used, either in these submissions or below. Third proposition, my Lord Justice Newey treats incidence of the burdens as central to the materiality of the change in identity of the parties for the purposes of the code. And it is not immaterial, this is proposition 4, to the site provider if the assignee operator with the benefit of the agreement doesn't also have its burden. And 5, it is not immaterial if the grounds of termination in paragraph 31 are impacted.
Sorry, can you say the last one again?
Yes, my lord. It's not immaterial if the grounds of termination, the site provider's grounds of termination in paragraph 31 are impacted. And they require that the person who is the party to the agreement is the one who's also subject to the burden. Paragraph 6. A new operator will therefore stand in the shoes where and only where it becomes the person currently entitled to the benefit and burden of the agreement.
Can I just get that one down properly?
Yeah.
The new operator will
Therefore stand in the shoes of the original operator where it becomes, and this is quote from paragraph 75, the person currently entitled to the benefit and burden of the agreement as operator. So before I get to my Lord Justice Fancourt's, Mr Justice Fancourt, forgive me, this afternoon, I'll end with this. Unless On Tower has the burdens, it's clearly not standing in the shoes. The change in its identity has not been immaterial. This isn't the sort of assignment that Parliament is intending to facilitate. There isn't, therefore, the justification for treating them as a party to the agreement when they plainly are not, in the way that the law normally understands a party to the agreement. Lord, unless there's anything you'd like me to deal with again before lunch, I will leave it there until lunch.
Yeah. So thank you very much, and 2 o'clock.
Rise able.